Hi, welcome to one and all. Myself Ramya Vashini. Welcome to a legal awareness program. Today's program we are going to give a brief introduction about scheduled tribes areas and schedule 5 and schedule 6 areas. Hi friends, today I am going to give a brief introduction about the scheduled tribal areas that is related to administration of scheduled and tribal areas under the 5th and 6th schedule. These are famously called 5th and 6th scheduled areas. Slightly under development areas will be specifically focused for development, and those areas are scheduled under tribal areas. Any area have more than 50% population of the same caste that to be belongs to a scheduled tribal people, and that community will be recognized, and also the territory or the provinces will be recognized by the government under Tribal Act. The scheduled areas are identified in 10 states: Andhra Pradesh, Jharkhand, Chhattisgarh, Himachal Pradesh and Madhya Pradesh, Maharashtra, Odisha, Rajasthan, Gujarat and Telangana. Why? The scheduled and tribal areas are separately bifurcated because the purpose is that to preserve and protect the culture and to develop economically and socially by empowering the people of that territory or the who belongs to the tribal areas, and also focused for good governance and also preservation of culture, art, the existence of the tribal people. There are some provisions are given under this scheduled and tribal areas. In the 5th and 6th scheduled areas, Union government can issue a binding direction to state with respect to administration of scheduled areas. Governors of state having scheduled areas have to furnish annually and a report on administration of other areas to the president. The governor is the authorized person to direct any law of parliament that related to the tribal areas. So there are some other provisions like governor can also make regulations with respect to business of money, lending or allotment of land and the transfer of the land, that also directed by the governor. And also these regulations are required presidential concurrence before they come into existence or force. Tribal advisory councils have to be set up in states having a scheduled areas and also in the states having scheduled tribe, but no scheduled areas. The tribal advisory council consists of 20 members, 3/4 of representatives of ST's community in the same state and the ST MLAs from the same state. Tribal areas, 6th schedule under Article 244 of 2 clause. Under this Article 244 class 2, the Meghalaya, Tripura, Mizoram, Assam are bifurcated as a tribal areas that are belongs to a 6th schedule. Why? Why this kind of bifurcation is made in the constitution? The purpose is to protect the ethnicity of the culture that belongs to the people who are stayed for long years, and to increase the development and recognition in the tribal areas, and the democratic devolution and protecting the land rights. The main cause to make the sixth schedule tribal areas because to protect the land rights of the tribal people. The basic provisions are identification of autonomous districts and creation of autonomous district councils and regional councils with substantial tribal population. Here, actually, in these states, autonomous district councils are created. These are regional councils that also entered into a administration of tribal population. Each district council shall consist of no more than 30 members. Laws made by the district councils are also require government or governor consent. Without the consent of governor, they can't do any law or any rules they cannot make. Over matters on which the autonomous district councils can make laws, state laws shall not extend unless the relevant ADC so directly. So, in the committee also, under this 244 class 2 article mentioned that in the council, the 26 are elected and 4 people are nominated by the governor. Even the district councils and regional councils have legislative powers to direct or to lead or to administer the people who belongs to the tribal areas. They can concentrate on the allotment and occupation and use of land, management of forest, use of canals, water course, etc. The regulation of practice of shifting cultivation, establishment of village and town committees, matters relating to a village and town administration, the appointment and succession of chief and handman of tribes, all aspects of personal laws that will be administered by the district councils and the autonomous regional councils. And also the executive powers also that belongs to a district councils to establish or construct or manage primary schools or dispensaries, markets, road and water transport, etc. And management of agriculture and also animal husbandry and also community projects, social welfare projects that also executed by the district councils of those states. And another thing, the financial powers conferred on the district councils and regional councils. The financial powers like to collect the taxes or levies from the district councils and also from the regional councils. They can also make some laws that related to our tax collection, creation of district and regional fund for fiscal devolution of resources from the state, and also they can make some land laws that related to tribal welfare. And also there are some judicial powers that can be administered by the district councils and regional councils, high court and also the district court to settlement of disputes among scheduled tribes only. For them there are separate disease courts, village court, village council and district council will be take care of that.